Okay, so what I'm going to talk about today is why you should always have an agreement with anybody that moves into your house, even temporarily. What I see oftentimes is that families try to do something nice for another family member or a friend or someone in need, and unfortunately it gets used against them. Here's an example. I had a client, and my client gave me permission, because this is just non-specific to my client. I'm not going to identify my client. Client let the nephew move in while the nephew was just getting situated. And I think the nephew had just come back from college, was just, getting back on his feet. Family lived in a different state. So the father and mother, obviously knew the nephew, of course, and they said, yeah, you can stay with us for a while while you figure things out. Well, here's a few problems, and this is what I want you to learn so you can avoid making foreseeable mistakes and therefore getting foreseeable outcomes when they are almost entirely avoidable. Now, almost entirely is different from entirely. Nothing is ever foolproof. The goal, like anything in life, is to put as many elements in your favor. You want to stack the odds in your favor and do everything that is within your power to control, because most things in life, if you haven't realized it yet, are not within your control. So the point of this video is to help you stack your benefits and your protections so you don't have to learn the hard way from dealing with a family member that you have to evict, and you don't learn the harder way of what the law is as a defendant in court. So let's get right to it. So what did these people do wrong? Well, what they did wrong was they didn't have any kind of end date. It was just basically an open-ended invitation to stay. Now, they had a verbal agreement, but what they didn't have was any codification of any agreement, either through email or text message. It was as if they wanted to make it as difficult as they could as possible. No text message, no email, no letter, no writing, no contract, just a handshake, if even that, which maybe before my generation used to mean something, but how much can you get on a handshake nowadays? Rhetorical question. So what they should have done was have, ideally, let me go from ideal down to least ideal, but still practical. Ideally, they should have had a month-to-month rent agreement, and they should have charged a nominal amount of rent, whatever you think is fair, even $10, just something so it takes the form of a rental agreement. Now, some people might say, well, that's going to be difficult because then I have to go through an unlawful detainer if I want to evict them. Well, what is your alternative? The point of having the contract allows you to bring an unlawful detainer. Now, this isn't to say you can never bring an unlawful detainer without a contract. And side note, what is an unlawful detainer? That's what California uses to get to an eviction. But let me bring it back to what's important here. The alternative to not have anything in writing is what? Self-help? You're going to throw the person out yourself? That is another example of learning the law as a defendant, because what could happen and what should happen if I'm representing the tenant is that you use self-help. And there are so few exceptions to this rule that you might as well just say there's no exceptions. You cannot use self-help to throw somebody out of your house in California. It is so dangerous to do this from a legal perspective. Now, there's always exceptions, but let's not swallow the rule with the one-off exception. What a lot of people do is they think, well, this is not a tenant. I've declared them not a tenant. I've declared them a boarder, a guest, a lodger. Well, maybe you've declared it, but are you a judge? Are you a judge in your own case? No, you're not. You never should be. You are going to have to prove your case to a judge, and the more evidence you have in your favor to show that this had an end date, if you want to make it as short as possible, you absolutely can. It's always easier to extend the duration of this so-called tenancy than it is to curtail it or throw somebody out because you either gave them a year or you didn't have anything in writing at all. So here's what you should do. Have a written agreement, ideally in the form of a month-to-month agreement, and have them sign it, you sign it, ideally initial every page. Make sure it's California compliant. As you'll hear me say periodically throughout these videos, the internet will always give you an answer, but it will not always give you the correct answer. So be careful when you go to something like eforms.com. Yeah, you'll get a California rental agreement, but has it been updated to reflect AB 1482? This is where it gets really technical and really complicated, because your house might be exempt from rent control and just cause eviction like AB 1482, but it's not exempt unless you provide the notice of exemption. So I'll get into that later, don't worry. This sounds confusing. I'm trying to make this high level before I go into the granular nuances, but if you have nothing else to take away this. You want to have an agreement, a written agreement with anybody that stays at your house, ideally more than a day or two. And do you ever know, unless someone has a flight home, unless someone obviously has a job that they need to get back to, do you ever know that they're actually going to move out? It sounds like it's ridiculous, but listen to things like handle on the law. How many people complain that my son, my daughter, my nephew, my niece moved in, and I thought it'd be fine for a few days, but now they're still here and I can't get them out, and they say that I have to evict them, and what can I do? They call the police, they try to get a restraining order. None of those things are usually effective in getting your unauthorized tenant out of the house. And they can bring in other friends. They have unnamed and unauthorized occupants. This is why you need some kind of rental agreement, even though it won't be necessary. And if the person protests, like, this isn't necessary, I'm offended. Well, maybe they should go be offended in their own house. They are asking you for a favor. And in exchange, since you're not charging them market rent, presumably, the least you could do is say, hey, to protect both of us, let's just make this crystal clear, because I totally trust you, but let's not leave any confusion, all right? You're telling me that you'll be out on March 17th, then let's just make it in writing, okay? I'm OCD, say whatever you need to say, but if they protest, then there you go. Now you have your red flag. Now you can stop this problem before it even becomes one. If they are actually planning to honor their word, then what would be the harm in getting them to write it down? And this is kind of a useful tell for most things in life. If someone tells you they're going to do something, if someone makes you a promise, why would they have any issue putting down their promise in writing? Well, the answer is they don't plan on actually honoring their promise. And you can tell early and quickly and at minimal expense to your time and your money when you call their bluff from the onset. So don't learn this lesson the hard way, and certainly don't learn it as a defendant. Learn it from me so you can avoid the problem before you even have to solve it.